and the proceedings can run smoothly. Just as a matter of housekeeping, I see in the invitation it was for both the 16th and the 17th. I have communicated to the parties that it is only set down for the 16th and not the 16th and the 17th. That's not going to be a problem.
My name is Tembeka Ngubatobe. I'm with Mr. Kamil Permit for Parliament. I believe this case will be finished in one day. The issues are fairly narrow and crisp. And I think Mr. Labuskar shares my view in this regard, given the conversation we had.
Thank you, Advocate Counsel. I just
agree,
any confusion about whether the matter is going to run over to both days, because the invitation said 16 and 17.
I think we both would be horrified.
Okay, then we may proceed. But before you start, Advocate Labuskachny, just a matter of housekeeping, and perhaps Advocate Labuskachny and Advocate Ngubatobe can just verify. In the matter, there is an application for admission as amicus by Black First Land First Movement. All I've got is the notice of motion. When my registrar contacted the parties finding out to ascertain what the position is in respect of the relief set out in Part B, we were just given a press release pertaining to the dismissal of the relief under Part A. So I'm then going to proceed on the basis that they are not persisting with the admission to be admitted as amicus. The position of the parties in this matter is, if they have any further communication with the application for Black First Land First Movement.
Well, Lady, they attended the hearing in respect of the Part A proceedings, but I'm unaware of them being involved at any stage thereafter. I don't think they are.
Advocate Ngubatobe, is that your understanding as well?
It is indeed my understanding. If they intended to participate, they certainly have by conduct abandoned that intention.
Okay, then we're going to proceed with the hearing, and the applicants then may proceed. Thank you.
As the court pleases. My lady, in this matter, the applicant acting for itself and for a host of its members applies under Part B of the proceedings for declaratory relief in terms of Section 1721A of the Constitution, to the effect that the report of the Joint Constitutional Review Committee dated 15 November 2018, or the adoption of it by the Joint CRC, is my lady, at the time of formulation of Part N Prayer 2 was not moot, but it has in the meantime been overtaken by subsequent developments as far as the processes that followed is concerned. Your ladyship would note, and our learned friends understood, that the relief that we are persisting with is the declarator in Part 1, and we submit that in itself is substantive and effective relief. No further relief other than the issue of costs would be sought. My lady, in developing our argument in this regard, it would be necessary to tap on the main issue and to give the court an indication we will address in developing our argument. Our heads are quite comprehensive, and I don't intend going through them, assuming that the court has opportunity to have regard to the authorities and the references that are germane to the various topics that we refer to.
The parties can accept that I have read the heads of argument and have had regard to the authorities in the presentation of the case.
As the court pleases then. My lady, the crux of the matter, as far as Part B is concerned, relates to the exclusion of a significant segment of public participation in the proceedings of the joint CRC by a third-party service provider known as Izilunco Staffing, and the subsequent endorsement of that exclusion by the joint CRC in the report of 15 November 2018. This flows from what we've stated in our supplementary founding affidavit in paragraph 6.3.4. Now, Milady, the crux of the issue is germane to one of the points raised by our learned friends. They suggest that we should or are in fact attacking the appointment of the third-party service provider, whilst the relief does not echo that approach. My lady, for purposes of clarity, we might just make clear what this case is about and what it is not about. It is about the legality of the decision by the joint CRC in adopting its report, or insofar as the report itself evidences a decision, the report itself. This is based on public law principles, and we will develop our argument with reference to grounds of review. Now, Milady,
on that point, in the initial founding affidavit, reliance was made on PAJA, and it was sought in terms of PAJA. However, in the replying affidavit, and it seems to be in the heads of argument, that PAJA has in a sense been abandoned and that the applicant is now proceeding on the principle of legality. Is that correct?
Milady, there's been no abandonment of PAJA as such, but this is an instance where we submit it makes no difference, because the principles informing a legality review and those relevant on the facts to a PAJA review overlap to the extent that it doesn't matter on which of the two one approaches the case.
Sorry, Advocate Labuschagne, it is important for me to have clarity in respect of where or on what basis you are proceeding. If it's in terms of PAJA, then there are specific grounds which were set out in the founding affidavit.
That is correct.
If it is the principle of legality, even though there's an overlap, there is a difference, and the test is also slightly different. So I need to know whether the attack on or the challenge to the validity of the report is in terms of PAJA or on the principle of legality.
Well, Milady, it's based on PAJA with an alternative of the legality. They are both before you, and they are both fully, we submit, developed.
Thank you.
Yeah. My lady, as far as the decision itself is concerned, our submission is that in seeking the relief, the applicant is not attacking the appointment of the third-party service provider. It contends that the rights of public participation and the right to fair administrative action were infringed by the committee itself when it adopted certain steps taken by the service provider excluding participation in circumstances when that would be unlawful. My lady, in order to explain whether that we are dealing with this, with the specific decision by the committee and as far as the report is concerned, it might be necessary just to take into account what is common cause. It is common cause that the assessment of submissions by members of the applicant, and there were more than 100,000 of those submissions, that assessment was done by a service provider and not by the joint CRC itself. If I could give references in this regard, it's the answering affidavit in the Part A proceedings, paragraphs 56.2, 60.2, 65.1. It is further common cause, my lady, that it is the service provider that excluded these submissions on the basis of there being duplicates. Now, my lady, that in itself, we say is irrational. Firstly, they were not empowered to exclude, They were empowered to analyze and report. The exclusion is something that the committee and that the service provider took upon itself. And we make that point in our supplementary founding affidavit. In paragraph 6.2.2 to paragraph 3. That's at page 568 to 569 of the papers. So this third-party service provider is given a mandate by the joint CRC. They are asked to do data capturing, and as far as the submissions are concerned, to do an analysis and to report. What the service provider then did was to record that there were some 630,000 submissions, of which they excluded just short of 180,000. That's almost 29%. And one must bear in mind that their mandate from the joint CRC was to determine how many of those who participated in the public participation process were in favor of the amendment of Section 25 of the Constitution and how many were against. So it was very much a head count, although this is not an election, one knows that. But their mandate was to report on how many are for and how many are against.
On that point, was this issue not dealt with by the full court in dismissing Part A of the application? And as that was the full court, and I'm sitting as a single judge, can I depart from that finding? Because there was a finding as to the approach of the service provider and its acceptance of that approach by the first respondent.
Lady, if I could, to basics as far as this is concerned. That court was sitting as a court in an urgent application, and it was assessing papers as they were at that time. They were vocal in not wishing to intrude upon the field of the court hearing Part B proceedings. They say so expressly. They
do
are
say
mindful
so
not to intrude.
They do say so. That court also made specific findings pertaining to the nature of the public participation, what was required, whether a head count was required for public participation, and the role of the service provider. And yes, that decision was made before the supplementary papers were filed. But the supplementary papers do not substantially or materially differ from the complaint or the basis of the complaint that was before that full court.
My lady, if what I'm addressing is the issue of res judicata and whether you are bound by that decision, then I think the principle is quite simple, and that is that where that court, being aware that there will be Part B proceedings, is bound, it makes its decision on facts which are not the same as those that are before you, then the purpose of their finding was merely to dispose of Part A proceedings. If your ladyship is correct that amounted to res judicata, then why are we here? And our submission is it's because it's not res judicata. The court au quo was not called upon to give a declarator in terms of Section 172 of the Constitution. The court that I'm referring to in the Part A proceedings did not have the record that was to be made available under Rule 53. That court did not have available to it the admissions that emanated from the further affidavits filed subsequent to that. And the case of Piccoli, which I might just give your ladyship a reference to, makes it clear that a court hearing a matter that will be revisited does not give a binding judgment binding on the court who hears the matter thereafter. The fact that the two judges were sitting does not disturb that principle. And our submission, therefore, is, my lady, that the findings of that court are not binding on you. It was based on different material, and in any event, this court is free to form its own view on this issue. The Piccoli case that I wish to refer to is Piccoli versus President of the RSA, 2010 1SA 400, Gauteng North, at page 403. Now, lady, this is very similar to an instance where a court hears a rule nisi on which there is a return date. And the court makes findings at the initial stage on whether to grant or not to grant a rule nisi, whether it has interim effect or not. When that matter comes before another court on the return date, that court is not bound by the findings of the first court. It is free to assess the matter and is in fact obliged to do so on all the material before it. And that is a principle which is well known. A name that comes to mind is Rolda versus De Souza. And I can give a reference to it, but the principle is that a return date, which is essentially nowadays a Part A, Part B scenario, is no different to that scenario. And for that reason, the court is enjoined to assess the matter de novo on the material for you. My lady, the paragraph that the court in its judgment referred to these Part B proceedings is paragraph 7. The court there says, nonetheless, these are but interim proceedings. We are mindful not to trench on the relief sought in the declaratory proceedings under Part B. So where that court itself disavows an intention of fettering your discretion, our submission is that you get the clearest of indications that this matter is not res judicata. It was not meant by that court to be a final ruling on this topic. My lady, getting back to the issue of which decision is being attacked, what is important is that the exclusion of the public submission were made by the service provider. That is an issue in which I've given you references. What is further common cause is that when the service provider tried to present its report before the committee in September 2018, everybody was critical of them and they were in fact stopped from presenting the report. It was ascertained that this is a labor broker, their qualifications were doubted, and their right to address that committee were placed in dispute, and that report was criticized for being deficient. One couldn't even identify the author of the report from its content. Lady, after the matter was then, the proceedings on about the 18th of September were concluded, the indications were that Parliament said that it will take control of this process and it would vet the issues which this service provider purportedly vetted. They never did so. In fact, when they adopted a report on the 15th of November, it is nothing more than a rubber stamping of the very report that they were critical of. And that we say their acceptance of a report that the committee was critical of is irrational. Secondly, what it amounts to is that the joint CRC endorsed the exclusion of almost 29% of written submissions, which were made by the service provider who had no business excluding submissions. It was called upon to analyze and report. Now, lady, in that regard, the court, the first court was wrong. They're suggesting that somehow the joint CRC itself considered the submissions and excluded them. That is not so, my lady. And we can do so with demonstrate that with reference to the papers. My lady, the first annexure to the founding affidavit, Annexure A, is the report in question. And if your ladyship were to have regard to page 52 of those papers,
yes,
now page 52, 53 and 54 under the heading Arguments for Amendment of Section 25. That is a copy and paste from the report if you compare it to the report of Isilunko at page 263 to 264. And what particularly is striking is that the exclusion by the service provider is merely adopted and endorsed in the report of the joint CRC. Now, my lady, if I could just get my computer to go to page 52. If it won't.
I've got it.
Okay, I have it. But lady, there we see at page 52, there is a section under the heading Statistical Information. Now, this is the committee's report. And in it, your ladyship sees the statistics of 609 submissions. Only 449,522 were valid, and analysis could be performed based on the contents of the submissions. They only analyzed the 449. Analysis could be based on the contents of the submissions. That's, in other words, what remained. And if one then looks at the rest of that paragraph, it says Table 2 provides a summary of findings regarding the views of members of the public. Now, my lady, this is quite telling because Table 2 is not made part of this particular report. Table 2, however, is the exact same summary you see following this, but in the report of the service provider at page 263. It's a copy and paste of their assessment of what was valid and what was invalid. And in that summary, the Table 1, summary of submissions at page 52, that Table 1 is in fact Table 2 of the service provider, and the statistics that are then referred to is that 65% of valid submissions were opposed to changing the constitution, whilst 34% were in favor of amending. Lady, it seems that the figures were distorted by the exclusion. Now, our learned friends might say, so what? This is not a matter, it's not an election. The committee is not bound by the number of submissions, and Parliament makes the decision in the end on whether to amend the Act. Well, my lady, it matters because Parliament appointed the joint CRC appointed the service provider to tell it how many are in favor and how many are against. That appears from 573 to 574 of the paper. Their mandate was tell us how many. And they excluded, as far as my client is concerned, over 100,000 submissions. As far as the DA is concerned, they couldn't even find their submissions in the records of Parliament. And the Institute for Racial Relations is in the same position. As soon as an electronic platform was utilized where the submitter could say who he is and what his contact details was, and pressed a button, they were excluded from consideration. Now that, we say, milady, is an infringement of the right to participate meaningfully. If more than 100,000 people put up their hands to say, we want to participate, we want to be heard, then the service provider was enjoined to report their position and include it in the statistics. However, they were just excluded en masse, as though they were not making a submission at all. Now, we made the point, milady, that it's one thing to say that 100,000 plus people were all making the same submission. In that event, one would say their submission is noted, and the fact that more than 100,000 people say so goes into the tally, the head count. What the service provider did was to say that because they are duplicates, they are not going to be considered and they were excluded from analysis. That is irrational. And we say that the committee, in endorsing that exclusion, itself committed an irregularity.
Now, I think, Advocate Labuschagne, it's common cause that events have developed, that the report was adopted by both the National Assembly and the National Council, and that a new committee was appointed. The relief that's been asked, the respondents in this matter take the point, or rather challenge the relief on the basis of mootness. Is the matter, or has the matter not become moot?
Milady, that is one of the topics that I intend addressing. And if I could just conclude my previous point to say that we say that public participation only means something if it is meaningful. Where people were excluded en masse on an irrational basis by a service provider, and Parliament rubber-stamped their exclusion, then we submit that those participants are the victims of an infringement of their right to fair administrative action. It's a constitutional right. They were excluded procedurally from consideration. Now, why it is important, my lady, is that the Doctors for Life case make it clear, which is also about public participation. And the reference is in paragraph 142. Your ladyship is free to have regard to it, but there are essentially two aspects of it. And that is that meaningful participation means, firstly, that Parliament and its committees must hear the voices of those people who participated. And secondly, when it comes to written submissions, they must receive those submissions. In other words, receive them for consideration. Now, on that element alone, the participation of these people was thwarted by a decision which we say does not pass constitutional muster. It is irrational, firstly, to permit a service provider to make an assessment and to exclude, and it is compounded by Parliament endorsing that exclusion without even itself considering the submissions. I say Parliament, it's obviously the joint CRC in this particular instance. So why we stress this, my lady, is it's going to become apparent to the exclusive jurisdiction point that our learned friends also raised. What is in focus here is the validity of the decision of the joint CRC. whether there was a failure of legality because the process was irrational. An irrational exclusion by a service provider endorsed by the committee we submit is an illegality which requires a declaration to that effect. And the reason why it is so is that section 172, dealing with constitutional matters, and the right to public participation is one of those, and dealing with the rights to fair administrative action of the applicants, these issues fall squarely within section 1721A, and they require a declaration of invalidity, which leads me straight into the mootness. My lady, the Gijima case and the Buffalo City case that we have referred to in our heads both make the point that section 1721A enjoins the court to declare invalid what is invalid. The Constitutional Court, or the Constitution, in one of only a very few instances, says the court must declare invalid, must. Now that is independent from the question of whether the court's jurisdiction to entertain a long delayed review, etc., is triggered or not. That case says, the Constitutional Court there says you must set aside, declare invalid.
But the Constitutional Court, sorry, the Constitutional Court has also, I think recently in 2020 said you need to consider the practical effect of the relief when deciding whether to hear a matter that is moot or not. So the question then posed to you is, if I declare this report or the adoption of the report invalid, what practical effect would it have?
Yes, my lady. Okay, the first point I was getting to is that because of Gijima and Buffalo cities, this court is required to declare invalid in terms of section 1721A, conduct inconsistent with the Constitution. Now, if the Constitution itself enjoins the court to do so, then the question of mootness does not arise. So the reason firstly is, why is it not moot? It's because the court must declare it invalid. Secondly, on a broader, and that is related to issues falling within the ambit of section 172. In other words, it must be a constitutional issue, which it is in this case. Now, my lady, the question, what flows from it, is really what your ladyship is concerned with now. If it is declared invalid, is there going to be consequential relief? Firstly, and if mootness is the reason why, in the facts of this matter, it is not necessary to grant further relief, is that not in itself just and equitable? Now, milady, when it comes to mootness,
I'm sorry, I don't follow that argument.
Okay, let me just reformulate it then.
Yes.
Why is it not moot? Because the court is enjoined by section 1712 to declare invalid what is constitutionally invalid. The facts, the arguments that I've advanced on the invalidity are not contested, my lady, and for that reason we submit it's clearly invalid and must be declared invalid. Now, your ladyship raises a different issue, and that is, where something is invalid and must be declared invalid, has the court got a discretion to say, but it doesn't have practical effects, I'm not going to declare it invalid? That's exactly why we refer to Buffalo City and to Gijima. The court doesn't have the choice. It must declare invalid.
The Constitution.
And the question,
sorry, just on that point, I've just had regard to section 172 2A. It says a court of the Supreme Court of Appeal, the High Court of South Africa, or a court of similar status may make an order concerning the constitutional validity of an act of Parliament, provincial act, or any conduct of the President, but an order of constitutional validity will have no effect unless confirmed. So the Constitution itself does not say must, it says may.
Lady, section 172(1)(a).
1A. Thank you.
That's the one that's in our notice of motion. That's the one referred to in Buffalo City and in Gijima. And remember, in those cases, just like mootness, long delay in a review application at common law, a court could say, I'm not going to entertain this application. I'm not going to hear you, even if you've got a case, because of the delay. Now, our submission is that if the Constitutional Court in Gijima and in Buffalo City versus Asla says that the Constitution itself enjoins you to declare invalid what is clearly invalid. You cannot skirt the issue, and you need to rule on that issue. The question of what the consequences would be are really relevant to section 1721B, namely what would be the just and equitable remedy if you were going to grant consequential relief. But let's park the idea of just and equitable relief, because we're not persisting with prayer 2, which would be a remittal. Would the declaration of invalidity, even on the common law principle, this is now on the common law principle, have practical effect? Well, lady, we say yes. And we say that it will have practical effect because it in itself, emanating from court, will be instructive to Parliament and its committees on how not to disregard public participation. So it would be instructive to Parliament and its committees on how to respect the public's right to participation through the acceptance and adoption of rational procedures in dealing with those submissions.
But isn't this already dealt with in the jurisprudence that exists? Let's assume that there was, for the sake of argument for this engagement, that there was a deviation from the principles required for meaningful public participation. Would the declaratory in this case make any difference? I hear what you're saying about the common law principle, that it would be informative to Parliament, but there's already a whole lot of constitutional law cases and Supreme Court cases that dictate what meaningful public participation is and how to go about that. So why would another declarator assist or be needed? Is the argument not that there isn't that guideline, but that if the court is with you, that the guidelines established by the case law and by the courts were not followed?
My lady, there is a premise to the question that your ladyship is posing to me that I have to address. And that is the premise that the court has a discretion not to declare invalid what is invalid in terms of section 1721A. We stress that the Constitutional Court authority says you must declare invalid, and the Constitution says so.
No, I hear your argument on that, but that question posed to you was in respect of your submission, that even on the common law principles, it would have a practical effect, because it would be instructive to Parliament as to how to give effect to meaningful public participation. That was the context in which that question was posed to you.
Okay, now let me move then on to that from a common law perspective. Our submission is, my lady, that in the case law that we have referred to, particularly Doctors for Life and the Women's Legal Center, those cases dealt with different scenarios. The one was about initiation of legislation, and Doctors for Life dealt with the question whether a court could intervene in a bill before it has been assented to by the president. Those cases all deal, the Doctors for Life case particularly, if that is what, dealing specifically with public participation. That case deals with participation in the legislative process. We are not in that dealing with such a process on the facts of this matter, and we and our learned friends are at Eden, that we are dealing with a stage before the legislative process. What we are dealing with is the right of the public to participate meaningfully in the business of a parliamentary committee before commencement of the legislative process. And on that issue, my lady, we have not seen case law. That's for that reason, the premise of what was put to me, namely that the matter is already regulated by case law, that is not correct. What we have here, my lady, is we're seeking a pronouncement by the court on whether the exclusion of people who intended to participate by a person who isn't even the committee to whom the submission was made, if that is unlawful, the court must say so. And Parliament and its committees must hear it. Because this is not going to be the first committee. This joint CRC is enjoined yearly to bring out a report on some constitutional issue on which public participation is a compulsory imperative. So for this reason, our submission is that this committee dealing with pre-legislative processes needs to be instructed and will be by the declarator. And for that reason, it covers territory not previously covered. The Doctors for Life case deals with instances. Yes. So, my lady, as far as the issue of mootness is concerned, I've made my point. The Constitution enjoins the court. Secondly, it will in any event have the effect in that it will be instructive of Parliament. This is something we dealt with in our supplementary founding affidavit. It's in paragraph 8, page 571. It will therefore have a practical effect on the way Parliament and its committees deal with submissions and the use of service providers. Now, Milady, as far as service providers are concerned, we are mindful thereof that Parliament has limited staff. And when one embarks on such a huge program, that there would be a need for administrative assistance. We have no qualms with that issue. What we do have qualms with is that where a service provider who was asked to analyze and report on submissions excluded on its own, in other words, made a value judgment to exclude as invalid submissions, pursued it, did so, and is thereafter, this exclusion is then rubber stamped by the committee itself. That, we say, is a manifest failure of procedural and rational legality, of procedural rationality, and it's an infringement of the right to fair administrative action. One gets to the same bottom line, both under Paja and legality. My lady, unless there's something specific, I'd like to move on to the exclusive jurisdiction point that our learned friends raised, if that's appropriate. I'm not watching the time. Is it T? Okay, that's right.
You may do so. I know, or rather my approach when dealing with matters electronically is to sit until we are done, unless the parties request a short adjournment. The reason for continuing is once the connection is made, and given the problems I've already experienced this morning, I'd be I would hate to take a break and then try to reconvene and then experience problems with connectivity again, unless the parties feel differently.
No, my lady, I think we are happy to proceed. I just did not want to be impolite if the court had another
no.
need. Okay.
No, no.
My lady,
sorry, Advocate Labuschagne, also I note that there is a condonation application in respect of the supplementary founding affidavit. Perhaps you can just touch on that as well. I don't know what the position of the respondents will be. Perhaps you may, it's up to you whether you want to do it now or in reply, because the issue is contested on the papers, and I'll hear Advocate Mukatobi on there, but it's not necessarily addressed in the heads of argument of the respondents.
My lady, my learned friend might correct me if I'm wrong, but I understand their position to be that they are not saying that they condone. They would leave that to the court to determine. And if I'm wrong, I'll be dealing with that in reply. But the essence of what we said in our condemnation is that we had a very long wait for a full record. And even now, my lady, the record doesn't include the submissions, etc., that we're talking about. But that being said, my lady, the third parties' appointment processes and documents pertaining to that only became available in September last year. And our submission is that the filing of the supplementary founding affidavit at the late stage was brought about solely by that. My lady, my client has previously accepted that the record given as the full record has been criticized for not going the extra mile to make sure that the record is complete. Now, in this instance, we did, and we insisted, and it took time. And for that reason, our submission is that the delay in filing the record as such was brought about by the process to obtain the Parliament's documents on the appointment of the service provider, so that the record is complete and that we are all singing off the same hymn sheet. So, my lady, I don't know whether there's anything specific, but I'll hear what my learned friend has to say in this regard. I'll head to it 2 days late as well, my lady. We were given a date and we complied with it, and if it was too late, we apologize, but that's the date that we had.
And this goes for both the applicants and the respondents in respect of the late filing of the heads.
Yes.
The court is indebted to the parties for the comprehensive heads together with the references to the authorities. And the heads are there for the convenience and the assistance of the court. And given that it was only 2 days late on either side, I'm not too, unless either party feels very strongly about it, both sides' late filing of the heads of argument are condoned. The reason I addressed the late filing of the supplementary founding affidavit is because it was specifically addressed in the respondents' papers.
Yes, as the court pleases, my lady, we're indebted to you, and I think the 2 days that our learned friends were late were probably a knock-on effect of our heads being 2 days late. I don't think there's any prejudice. We apologize to the court and our opponents if it inconvenienced them. Either way, my lady, getting on to the next topic, and that is that point that our learned friends raise and persist in, and that is that they say that the Constitutional Court has the exclusive jurisdiction in this case to rule on what we are seeking in Part B. And my lady, in order to dispel this notion, I'm going to make a reference to a few cases that would be instructive. My lady, the principles are firstly that the section that our learned friend relies on needs to be narrowly interpreted. It's section 167 sub 4E of the Constitution. And it grants exclusive jurisdiction to the Constitutional Court regarding a failure by the President or Parliament to fulfill a constitutional obligation. Now, the Constitutional Court, in a number of cases, including SARFU, the Women's Legal Center, and Doctors for Life confirmed that this provision needs to be narrowly construed, as opposed to section 1722A, which your ladyship referred me to a bit earlier on. That is one that gives courts the power, not just the Crown Court itself, but courts in general the power to pronounce on certain acts of Parliament, the President, and etc. In other words, they are not matters falling within the exclusive jurisdiction of the Constitutional Court. Now, section 1722A, which gives a court such as the court in which your ladyship presides, a power to rule on these issues, that is to be interpreted extensively. But the exclusive jurisdiction provision our learned friends rely on needs, as a corollary, to be interpreted narrowly. And the authorities show that the Constitutional Court will only, in very specific instances, endorse its exclusive jurisdiction. And it would be, there are two principles that have evolved. The one is that because the section 1674A, refers to constitutional obligations imposed on the President and Parliament, the first argument for exclusive jurisdiction would be what is called agent-specific obligations. It must be an obligation of the President alone or Parliament alone, but not in conjunction with others. That is not a difficulty in this particular instance. The second is, however, the so-called crucial political areas debate, and that is that the exclusive jurisdiction of the Constitutional Court, as far as Parliament and the President is concerned, would be triggered by politically charged questions. In other words, questions which infringe or appear to infringe on the separation of powers. And the reason why the Constitutional Court is given exclusive jurisdiction in cases like that is because it, by virtue of it being the custodian of the Constitution, has political legitimacy. That is what the authorities say. So everybody trusts the Constitutional Court with politically charged questions, and the more charged that they are, the more likely the Constitutional Court is to assert its exclusive jurisdiction. So this section 1674E, ring fences areas of intense political contention for the exclusive determination by the Constitutional Court for the reason that it has political legitimacy. Now, we're not dealing with that particular instance here. The Doctors for Life case perhaps demonstrates this clearly. If I could refer your ladyship in that particular case to paragraphs 18, 19, and 20. And before reading it, my lady, if I could just explain why I'm going to refer to it. The court there says, what is the issue before us? Is it a failure of a constitutional obligation, or is it something else? Because it has to be a failure of a constitutional obligation before the exclusive jurisdiction provision can be triggered. Now, the court in the Doctors for Life case says, but that doesn't mean everything that Parliament does should be determined by the Constitutional Court. Even if it amounts to what can be described as a failure of its constitutional obligations. For example, my lady, if Parliament takes a decision which breaches the fair administrative, the right to fair administrative action under Section 33, as we say is the case here, the source of the dispute is the breach of that fundamental right. It's not the failure to comply with a constitutional obligation, although in a sense one could say that Parliament has failed to comply with its obligations. So that distinction meaning that it is a fact-specific inquiry, emanates from paragraphs 18, 19, and 20 of the Doctors for Life case. Paragraph 18 starts with this debate, and it says, in the case of a law that infringes a right in the Bill of Rights, the primary source of the dispute is the breach of a right. The dispute flows directly from the infringement of a right in the Bill of Rights. Although inevitably this means that Parliament has failed to comply with its constitutional obligation, this is not an obligation contemplated in section 1674E. It concerns the validity of the impugned law and not the failure to fulfill an obligation. Now this continues, and in the end, in paragraph 20, the court says, well, you've got to determine the facts first before you can isolate the question on whether one is dealing with a failure to fulfill a constitutional obligation or whether the source of the dispute lies in the breach of a fundamental right. We've already indicated in our address, my lady, that the applicant has pinned its colors to the mast by alleging a breach of its fundamental rights. It does so in its Rule 16 notice, 16A notice, and in the papers where it says that the process of excluding these submissions is an infringement of the right to fair administrative action, in that it makes a nonsense of the meaningful public participation of more than 100,000 people in the proceedings of this particular committee. So, my lady, on the issue of exclusive jurisdiction, our submission is that the case of Doctors for Life, where it was held that the court does have exclusive jurisdiction on an issue related to public participation, it is instructed for the reason that it in itself deals with the participation in the legislative process. And in that particular case, there wasn't such a public participation process before the National Council of Provinces. And the Constitutional Court assumed its exclusive jurisdiction in that case. But the very judgment we are dealing with also says that you've got to be fact-specific in determining whether there's a failure or a breach of a fundamental right. And we, in this instance, on the facts before your ladyship, are dealing with a pre-legislative process. And for that reason, Doctors for Life is not authority for the fact that the court has exclusive jurisdiction. The case itself explains why. So, my lady, we submit that the Constitutional Court does not have exclusive jurisdiction. We would probably be sent packing had we gone there on the basis of what I've just referred your ladyship to in Doctors for Life. We submit, therefore, that there is no basis on which these point in limine on jurisdiction could be upheld. My lady, this thing takes me to the grounds for review, and that is where I would be concluding my address, subject to any further questions that your ladyship may pose.
Fine, you may proceed. Thank you.
Thank you, my lady. My lady, the grounds for review are those that are developed in the Part A proceedings and also in the supplementary founding affidavit. And what we essentially say is that the joint CRC, in adopting the report of 15 November, failed to take into account that approximately 180,000 written submissions to that committee from the members of the public who were exercising their right to participate had been excluded by a service provider. And we've set out the provisions of Section 6.2 that we rely on, Section 6.2, C, E4, and 2.1. We further say, my lady, that the joint CRC, in adopting the report, failed to properly take into account the fact that it's the very report that it itself distanced itself from in September 2018 that it adopted by cutting and pasting various components that it was critical. That we say is irrational. But we also say that the joint CRC therefore abdicated its duty to assess submissions to a third party. And this brings us to the topic of the delegation topic that we've developed in our heads of argument. Now, my lady, the case law and SARFO in particular say that there are three types of abdication of a public power. The first would be where the person empowered to do a certain act is itself a delegatee who then unlawfully sub-delegates. That would be an abdication, which is unlawful. The second instance would be where the committee in this particular instance would act upon the dictates of a third party who is not empowered to do what the committee could do. Now, we say that the service provider unlawfully excluded valid submissions as though they were invalid, and the committee endorsed it. That we say is an abdication in the sense that they took their cue from the service provider in adopting the exclusion. That we say is that they were following the dictates of the third party, and we deal with that in our heads, in the founding papers, paragraph, and the empowering provisions for impugning that conduct is section 6.2a, Roman 1 and 2 of PAJA. The third instance of abdication, my lady, is the so-called passing the buck principle, which also finds application in this case. The committee had the duty to deliberate on the validity of submissions, but subcontracted it and then permitted the service provider to itself exercise a power that the committee had, and that would be to determine whether submissions are valid or not. And that is a third instance of application of powers. We've used the word delegation. It is a word that is broader than just what we've suggested at this stage. But our difficulties with the service provider is that it exercised a committee power, and the committee power just endorsed it. To that extent, the committee abdicated its deliberative powers as far as the validity of submissions is concerned to a service provider. My lady, I've already made the point that portions of the service provider's report were included as a cut and paste into the report by the joint CRC, and where the committee, referring to the service provider, at page 46 says that the summary of findings is presented later in this report. Those are the findings of the service provider that they've just endorsed. We therefore make the submission, my lady, that this isn't for you. There's been a clear breach of a fundamental right. It's the right to fair administrative action. And for that reason, the relief that we seek in as far as the declaration under section 172(1)A is concerned is competent, and in fact, under the authorities of the Constitutional Court, are a judicial imperative. They need that conduct must be declared invalid. My lady, we have made our principal submissions. Our heads are more elaborate than what I have addressed. We persist in what is stated there, unless there's something specific. What remains really is just for us to move for the relief in Prayer 1 of Part B, together with costs. Such costs to include the costs of 2 counsel. My lady, the costs of Part A were reserved, and our submission would be that if we are correct that the finding of the conduct of Parliament does not pass constitutional muster and is to be declared invalid, then that means that the costs of Part A should form part of the costs of Part B, and that the applicant should be entitled to it. That is not despite the finding of the court au quo, because they did not wish to entrench on the position.
Advocate Labuschagne, I'm sorry, you froze for a while. So I didn't hear any submissions after you said that the cost in Part A were reserved, and if you are correct, then, and at that stage you froze.
Yes. My lady, what we're essentially saying is that the costs of Part A should be regarded as though they are part of the costs of Part B, because they deal with fundamentally the same core issue. And if your ladyship is with us, that the conduct is that the decision to adopt the report is invalid, then we should succeed with costs. If your ladyship is against us on the issue of costs, as far as Part A is concerned, we submit that the buy-watch principle is applicable. Our learned friends have purported to take us to task as though there was something malicious in what we are seeking to do. Our submission is, my lady, that my client is asserting a constitutional right on its own behalf and its members, a right to fair administrative action and to meaningful public participation, and that even if it were unsuccessful, that the buy-watch principle would be applicable. So no costs in that event. My lady, we will, as far as the further issues are concerned raised by our learned friends, we wish to raise one issue, and that is that it is apparent that the respondent assumes a political objective in these proceedings. Now, my lady, we cannot see how a finding in our favor will in any way hobble processes which are not serving before this court. They are independent on the papers. The legislative process as far as land reform is concerned. And for that, what we are seeking, my lady, is that an endorsement of the right of the public to participate meaningfully in committee proceedings in a pre-legislative process. And the concerns we raise would be as valid if they were raised by any of the political parties who had their submissions excluded. So it's not a politically loaded question, and we would therefore not wish to elevate it to anything more than an assertion of a constitutional right to fair administrative action. As the court pleases, my lady.
There's just one issue, if you can just give me, there's just one issue. If you could just give me a moment, I just need to find the papers quickly. Advocate Labuschagne, if you go to page 570 of the record, you refer to the constitutional provisions relevant to public participation, and you mention section 59 1A, section 72 1A, and section 69E of the Constitution. There is no section 69E of the Constitution. So I don't know if that was a typo or if there's a specific other provision you meant to refer to.
My lady, you are addressing the dummy. I can ask the ventriloquist what he had in mind, and I'm sure it's a typo. But the section 72 is really the corollary as far as public participation is concerned in proceedings of the NCOP. Section 59 is the one related to the National Assembly. So there are provisions which echo one another in proceedings of committees of either. Now, this particular one is a joint committee of both the houses, and for that reason, the constitutional provisions in section 59 and 72 are all triggered, but they're essentially the same principle of public participation.
We reply.
My lady, if I could just correct the section referred to in reply, it seems that I'm not getting a clear answer. I'll just send you as the court pleases.
Thank you. Then Advocate Nkatobi.
Thank you, my lady. I will address 4 topics. The first one is mootness. The second is rationality. The third is the relief. The fourth is the question of exclusive jurisdiction. If I can start then with the question of mootness. The facts underlying the defense of mootness, your leadership would have seen, appear from page 594 of the record. And it's crucial to just recap what those facts are. One, we deal with this from paragraph 7, where we say these are the facts underlying the objection on mootness. What we know is the application was dismissed on the 30th of November 2018, being the Part A application. On the 4th of December, the report, that's the report we are dealing with today, was adopted by the National Assembly. It is no longer a report of the Joint Committee. It is now a report of the National Assembly with any flaws that it contains. But subsequently, on the 5th of December, a day later, the National Council of Provinces also adopted the report. So not only did the National Assembly adopt it, the NCOP also adopted. A day later, on the 6th of December, the National Assembly established a new ad hoc committee, which will then consider the amendment to Section 25 of the Constitution. Now, what is crucial in paragraph 7.3 is it explains what the new process will look like. The current ad hoc committee is not constrained, not bound by this report. It will take it into account as one of the sources, but it has its own agenda, it has its own program, and it can call expert witnesses, it can review new submissions, it will undertake a full public participation process.
Is this why it was referred to as a non-binding report?
Exactly. So that has happened. A year later, sorry, not a year, a couple of months later, at 7.5, 21 February 2019, the National Assembly dissolved Parliament. So not just the committee, but Parliament itself was dissolved in the light of the general election that were held in May 2019. A new Parliament is then elected, and then it becomes the new legislative body for the country. Thereafter, it decides on its own at paragraph 7.8 on the 25th of July 2019 to revive the ad hoc committee. It's not reviving the Joint Constitutional Review Committee, it's reviving the ad hoc committee, which will commence its own process, not bound by anything that happened in the 5th Parliament. It's commencing its own process. And then thereafter at 7.9, this is just the icing on the cake. There is now even a bill, a draft Constitution 18th Amendment Bill, which is to commence a process that will allow the ad hoc committee to introduce legislation and that will provide explicitly for the amendment of the Constitution. And the comments were to be submitted at that stage by no later than the 31st of January 2020. The process of amending, which commences with the bill, also includes full public participation under Section 59 and under Section 72 of the Constitution. So those are the facts underlying mootness. This Constitutional Review Committee did its work, finished its work. Its report was not binding on anyone. An ad hoc committee was set up. It has produced a bill. A bill, of course, is binding. The work of the ad hoc committee in relation to the production of the bill has entailed full public participation. So the fact we make here is that the entire work of this committee has been overtaken by events. Its report was not binding on anyone. The events that overtook it entail the production of a bill. The production of the bill entail public participation. There are no rights that remain that may be infringed. There are no interests that remain that are capable of infringement. Now, your Lordship, your Ladyship knows the law on mootness. If the order that is sought is pointless, in other words, it serves no purpose, a case is moot. If the relief that is sought has no practical effect, the case is moot. This is precisely where we are. You are asked for a declaration of invalidity, but it is a wholly pointless declaration of invalidity because the report was produced, it was not binding on anyone, and subsequently a bill was produced which is binding, but that bill entailed public participation. So that should put paid to the argument around why this case they claim is not moot. The question is a simple one. It's been overtaken by events. Secondly, anything that you say, your Ladyship is required to say about a declaration of invalidity will produce no practical outcome. My learned friend tries to rescue the problem of mootness that he faces. And by the way, these facts that are narrated here at paragraph 7, 8, and 9 are common cause. In the replying affidavit, they are not disputed. So it has to be accepted that the factual substratum of the mootness argument is as pleaded by the respondent. Even if there was a dispute on Plascon Evans, your Ladyship would be bound by the arguments or the facts that are set out in the answering affidavit. So my learned friend's attempt is twofold at rescuing the problem of mootness. One, he says, well, it is still necessary to get a declaration because it will give advice to Parliament in relation to the process before legislation commences, right? But that is purely advisory. In terms of practical effect, it still has no practical effect because on his own construction, it is simply instructive in relation to what should happen prior to the commencement of legislation. But there is a fundamental problem. His own heads of argument rely on Section 59(1), Section 72(1), and on Doctors for Life to establish the legal cause of action. So he himself relies on these cases, which already establish fully the legal position in relation to public participation. And there is no need for any new case law on this because Section 59(1) firstly speaks about public participation in legislative and other processes of committees. Section 72 says the same thing, but in relation to the NCOP. Doctors for Life and the cases that have come after it apply in relation to the legislative and other processes. So even where these are not commencement of legislation, because it says other processes in Parliament, the authority in Doctors for Life applies, and the authority in Doctors for Life remains binding and law. In fact, the most recent case on this very point is the case of Lamosa at the Constitutional Court, decided now in 2018, where the Constitutional Court had to decide whether or not the amendments to the Restitution Act, to the Land Restitution Act, were lawful or not. And it decided the case by not by inventing a new principle. The Constitutional Court itself is not inventing new principles, but by applying the principle it developed in Doctors for Life. So insofar as the legal position about the entitlement of the public to participate in legislative and other processes, because this would fall in other processes if my learned friend is right, that this is not legislative, but it's prior to legislation, because his entitlement to full public participation still flows on his own pleaded case from section 59.1 and section 72.1. Those are the entitlements to public participation. So the law on the point is established, but it would not be this court's function, with the greatest respect, to give advice to Parliament. And then my learned friend says, no. You have an obligation flowing from section 172.1a of the Constitution to grant declaratory relief. And as authority for that, he relies on Buffalo City and on Ujima, yes. Now, your leadership is invited to consider Buffalo City, which is the 2019 judgment. Buffalo City did not say a court must give a declaratory order in a case that is moot, which is what we are dealing with here. Buffalo City simply said, where there is a delay, but the case is not moot, where there is a delay, right, you may declaratory order. Of course, that case, Buffalo City, was not moot. The case itself remained live in order for an order to be granted. So one must distinguish between cases of delay and cases of mootness. A case is moot not because of delay. In fact, there may be no delay at all, but the case may be moot because the order sought will have no practical effect. A case may delay, but the order sought will still have a practical effect, such as the case of Buffalo City. But mootness operates on the grounds of practicability of the order that is sought. So Buffalo City, Gijima are not cases that engage the doctrine of mootness. Cases that engage mootness are cases like the President of the Republic of South Africa versus DA and others. Your leadership remembers the case where the DA sought the record of consultation in relation to the dismissal of Mr. Godin as a minister. What had happened subsequently, which is why the facts in this case are crucial, what had happened subsequently is that a new cabinet was constituted. Mr. Godin came back not as Minister of Finance, but as Minister of Public Enterprises. But the fact of the matter was that it was no longer necessary for the court to decide whether or not his dismissal in the first place was lawful. And therefore, the production of the record had become moot. And that is what was found in that case, that there would be no point in deciding the appeal because it has been overcome by the events that have subsequently transpired. The other case is the Legal Aid of South Africa case versus Makiduana and others. Your leadership remembers the case. This was a case about the the provision of legal fees for the victims of the Marikana massacre when they wanted to appear before the Judge Farnham Commission. Initially, the legal aid resisted the application, but in the interim, it agreed to provide the funding. The Constitutional Court says, once you had decided to provide the funding. It became unnecessary or moot for us to decide whether or not there was an entitlement to the funding in the first place. And on both of those cases, they dismissed the cases on the grounds of mootness. So the fundamental factual basis is strikingly similar to Makiduana, as well as the DA and Godan case, that the events have overtaken the original complaint, such that the original complaint becomes entirely purposeless to decide. So on the facts, to sum up the debate on mootness, on the facts, we have incontrovertible arguments to show that the case is moot. The reliance on Buffalo City and Gijima is a mistaken reliance because those cases deal with delay. They do not deal with mootness. Number three, the cases that deal with mootness, Legal Aid and Godan, establish quite clearly that where the events have overtaken the original decision, such that it becomes pointless or useless or ineffective to grant remedy, that case should be found to have been moot. Number four, the invitation to give advice to Parliament in relation to pre-legislative processes simply does not make any sense in the light of the fact that the legal source for the arguments is Section 59(1) and Section 72(1). They deal with both legislative and other processes before Parliament and its committees. And the law on that is clearly established from the cases like Doctors for Life, and the most recent being the Lamusa judgment of the Constitutional Court. So there is just no case that my learned friend can sensibly mount on mootness. The case should be dismissed because it is moot. On rationality, which is my second argument, the argument that is made on rationality is twofold as we understand it. The first claim is that Parliament erred by the endorsement of the report of the service provider. The second is that regardless of whether the error was in the endorsement or not, the exclusion itself was an irrational act of exclusion. Now, to deal with the first issue around the exclusion. Now, my learned friend is driven to the argument that Parliament did not itself decide on the exclusion. The exclusion was decided by the service provider. But of course, he accepts that the appointment of the service provider was proper. And he accepts that Parliament could not be expected on its own to conduct each and every aspect of the work. But here is the point, and which is a point that was endorsed by the full court that had Part A. When the service provider acted, it acted as agent of Parliament. It did not act independently of Parliament. It was implementing a mandate that it received from Parliament. So it was Parliament that was acting via the medium of a service provider. It will be similar to an affidavit drawn up by a client. Everyone knows that the clients do not draw up these affidavits themselves. These are drawn up by attorneys, and the client owns up to it. We see the clearest example of this in the way in which Parliament endorsed the contents of the report of the service provider, and it adopted those as its own. This we know from the answering affidavit filed in relation to Part A. And I just want to take your leadership through what was pleaded in Part A by Parliament itself, which is from page 356 at paragraph 73. So there we deal with the issue of finality, which I've already dealt with it. And then paragraph 74, we deal with the voluminous papers. And then here is where they start dealing with the exclusion at paragraph 75, page 357. He says at page 21, now it is dealing with the report of Parliament. Now this is Parliament speaking. and this is an affidavit signed by Dr. Matole Motshekga, it's Parliament itself speaking. An explanation is given of why certain written submissions were excluded. This was due to duplications, blank submissions, unrelated emails, and inquiries. This means that they were considered, but ultimately discarded because of the flaws therein. This appears to be common cause between the parties. Now, this is a version given by Parliament, which is, we've got this report, we've asked a service provider to look into it, we ourselves have applied our minds to it. And then it says, the latter four categories are thus properly explained and examples are provided. AFRIFORUM does not engage on this reasoning. It simply makes the bold allegation that they were wrongly excluded, and they were not. And then it explains blank submissions in the email were blank, nothing more to them. Unrelated emails pertaining to emails of a personal nature, including spam and adverts, nothing to do with the matter. Inquiries were just that, and here too, one could not extract anything from them to include in the final tally. They were asking questions, not making submissions. Then paragraph 74, which is the biggest number. Regarding the duplicate submissions, here the matter is slightly different. It seems that institutes such as the Institute for Race Relations created pre-typed email. Anyone wishing to send this pre-typed and copy and paste email would click a link and it would send an email using the IRR's email address. The only change would be that at the bottom of the email, a different email would appear, i.e. that of the sender. The content was exactly the same, but perhaps different people endorsed the same position. There were 176,780,000 of these duplicate emails. The point remains that the contents of the emails were all captured and taken into account. It was simply the duplication that was not counted. Having regard to the purpose of the submissions not being a referendum, the inclusion of these emails as the submissions would not have bound the JCRC. It could still exercise its separate discretion as it did. The pure numbers game that AFRIFORUM seeks to play is meaningless and does not constitute irreparable harm. Indeed, the fact that AFRIFORUM can bleat about the true statistics shows how pointless the application is. So 2 points are made here. The first is that the parliamentary committee members themselves applied their mind as to why these categories were categories to be excluded. This, of course, does not mean they themselves personally read each and every submission. It would be ludicrous and absurd to expect them to do that. In fact, the full court accepted that it would be ludicrous and absurd to expect each and every member to read each and every submission. The point is that this was a qualitative function. They explained why 176,000 submissions were excluded. One needs to find that this explanation that has been given by Parliament on Plascon Evans or any principle for that matter that one applies in motion proceedings. One needs to find that this explanation can be rejected on paper without more. There is no basis to reject it on paper without more. The full court expressly endorsed it. In fact, my recollection, I stand to be corrected on this. My recollection in argument in relation to Part A is when my learned friend was pressed by the full court, whether or not his case was that they were required to read each and every submission. He accepted that that would be indeed a ludicrous proposition. What was important is they needed to give an explanation why certain submissions were excluded. And they gave a full explanation for the exclusion. So that is by reference to the actual evidence that was before the court. That is why it is not surprising that the full court expressly accepted the explanation given by Parliament. We know this in several parts of the judgment where they deal with the process that was followed. We see this from paragraph, I think it's from page 11, where they deal fully with the entire, yes, it is from page 11, from paragraph 15, where they deal with the third-party service provider, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, And they even deal with the exclusion of the applicant's own submission, 27, 28, 29, 30. So it is a most comprehensive exposition of the evidence that was done by the full court in Part A. If one is to dismiss those findings, as my learned friend is asking, I accept that they were Part A findings and you are dealing with Part B. But if one is to dismiss the full court's findings, which are comprehensive, fact-bound, and address each and every complaint, one needs a strong and a compelling reason. The best that my learned friend could do in relation to this issue was to say, well, you are not bound by them. Well, fine, we accept that. But it was also to say, well, it's because they were wrong in finding that the members of parliament themselves looked at them. Now, of course, members of parliament could not say that we read each and every submission. What they were required to explain is what was the justification for the exclusion, which they fully did. And that justification remains, and it was accepted by the full court. So the real point here is, if you want to depart from such strong findings, thorough findings of fact, one needs a very strong reason, which will say they got it wrong, right? They got the facts wrong, they got the law wrong, and I'm getting it right. There is no such argument that can be mounted meaningfully in this case. So on rationality.
Sorry,
Yes.
Advocate Nkatobi, to interrupt you mid-sentence. The argument of the applicants were as well that at the time that those findings were made, the full court did not have the benefit of the supplementary papers nor the Rule 53 record.
Yes,
Would
well,
that in any event affect the argument that the fact-bound analysis
yes.
resulting in the decision of the full court on the role of the service provider and public participation, does that in any way undermine or disturb that fact-bound decision?
No, my lady, not at all. Because I read the supplementary affidavit because I wanted to see in what way has there been a material change to the applicant's case. Nothing. What they've been able to do is a comparison of the draft report produced by the service provider and the report as adopted by Parliament. And then they've now been able to say there has been a cutting and pasting. That is the highest watermark of their case. But those were always the facts before the full court. It was always known that the full court relied on the work undertaken by the service provider. And it was always known that the committee endorsed the findings of the service provider. It was always known that the committee adopted those findings as its own. So to say that the case has changed simply because you are now claiming a cutting and pasting, which was always your argument in Part A, and it has not shifted at all. Even these arguments about delegation, even these arguments about irrationality, these were always the arguments that were before the full court. So it is not as if there has been any revelation from the Rule 53 record. The case of AFRIFORUM has not changed at all in substance. Of course, at the level of rhetoric, it probably is much more forceful to use the term cutting and pasting, which is now the term that is being repeated. But of course, this court is undertaking a qualitative assessment of the facts. At a qualitative level, we have the same facts. We knew that the committee had adopted the report of the service provider. We knew the committee had employed a service provider. We knew the service provider had provided a report. We knew the service provider had done the initial sifting and the initial exclusion. And that was always AFRIFORUM's case in Part A. Even that issue of the exclusion, this was known to the full court. So nothing at a qualitative level has changed. And if you look at their supplementary affidavit, the best that has been said as new is the allegation of cutting and pasting. And the way that cutting and pasting works is by the comparison, which they've done, basically done a crude comparison of what the service provider did, and we know it was Isilumko, and then they've done another one, and they said, oh, look at the words, they are the same. But that cannot disturb the findings made in the full court. So, my lady, what we say here on rationality is that Parliament has given an explanation. It's not running away from the fact that it adopted and endorsed the findings of its own service provider. There's nothing wrong in doing that. Anyone who has had anything to do with the state knows that the state frequently outsources. But that person is acting as your agent. So you endorse what they have done because they're doing it for you. There is no basis to disturb the answering affidavit, which expressly says, we've looked at them, we've endorsed them. We think that the exclusions are okay because the exclusions can be explained through a rational process. The High Court, in the full court, which is a two-member court, did a comprehensive analysis of this. If one wants to depart from it, one needs a very, very strong reason. Here, it is a very, very flimsy basis that is being advanced to depart from the findings. So that is so far as the rationality. I must confess to being utterly confused about the abdication argument, because we are not dealing with another organ of state, which is where a typical abdication arises, where Parliament abdicates to the executive, a function that belongs to Parliament. We saw that in the case of Justice for All versus the President, where Justice Nwabo's term of office was extended by a presidential act rather than a parliamentary act. And there was an argument about abdication. But there can be no abdication as a principle where one is dealing with the appointment of a service provider, because the service provider steps into the shoes of Parliament. It's doing the work of Parliament. It's been appointed by Parliament to do its work. It's like if an advocate is asked to prosecute a case in Parliament. It's Parliament that is acting through the medium of an advocate. Parliament does not now abdicate its prosecutorial function. So the term of abdication or the term of delegation is a misnomer in this case, because the third party service provider is an instrument, which is an agent of Parliament. So it's unclear how they have now imported this concept of abdication, where what is really taking place is that a service provider is instructed by Parliament, go and perform the sifting exercise. We have the terms of reference. We'll give you some money for doing it. Members of Parliament haven't got the time or the inclination or the skill or the ability to do this work. You do it for us. When you produce a report, we will endorse it as ours. If we do not agree with it, we will tell you we don't agree with it. But abdication in those circumstances simply does not enter the equation at all. But in any event, on the facts, there is no abdication, because on the facts, all we have is members of Parliament appointed a service provider. It's done the work, but that work is regarded in law as having been done by Parliament itself. So the idea of abdication simply does not come into it. So we know then that there is no problem of rationality. We also know that there is no problem of abdication. And then the basis, the legal basis for our learned friends will then remain as section 59.1, section 72.1. And here, my lady, we get somewhat confused by our learned friends' argument. Because our learned friend says they are relying on PAJA, but at the same time, in their heads of argument, they are relying on section 59 and section 72 of the Constitution. Both of those sections are obligations, right? Obligations imposed on Parliament. Section 59.1 imposes an obligation on Parliament. Section 72 imposes an obligation on the NCOP. And that is the cause of action that is expressly relied upon by our learned friends. Leadership can have a look at their heads of argument, which is at paragraph 49 and paragraph 50 and paragraph 51 and paragraph 52. Now, that's where they say, you violated our rights in the following respects. In paragraph 49, they say it's section 59.1, section 72.1 of the Constitution place a duty, right? Now, a duty is just another term for an obligation. And we know this because the section 59.1 says the National Assembly must facilitate public involvement in the legislative and other processes of the Assembly and its committees. So whether or not my learned friend is talking about the legislative process or is talking about other processes, the source of that obligation or duty, as it is called in paragraph 49, is still section 59. It's expressly said so in his own heads of argument. The same thing you find in section 72, public access to and involvement in the NCOP. The National Council of Provinces must facilitate public involvement in the legislative and other processes of the council and its committees. But both of those are obligations that flow directly from the Constitution. Now, PAJA itself contains an exclusion in relation to legislative processes in the definition of administrative action. So administrative action is defined and then they say who may do it, etc. But in section 1DD, it says it excludes the legislative functions of parliament, a provincial legislature, or a municipal council. So insofar as parliament was engaged in a process to test the legal validity of the constitutional validity of section 25, it was clearly engaged in a legislative process. And we also know that the source of this committee was section 45. So the source of the specific Constitutional Review Committee is section 45(1)(d). That's the section that imposes a duty on the National Assembly to establish joint rules, among others, to regulate the business of the Constitutional Review Committee. So that's section 45(1)(d) sub 3. So the three sections taken together, the two that are expressly pleaded by AFRIFORUM, the section 45, and then the case that they rely on, which is at paragraph 50 of their heads of argument, which is Doctors for Life. It expressly deals with public participation when you are engaged in a legislative process, but it doesn't matter whether you limit it to legislative process because the section is broad enough to include other processes. But those are obligations placed on Parliament, and those are excluded within the definition of administrative action in PAJA. So it seems to us with respect that PAJA doesn't enter the equation whatsoever because of that exclusion. But I have shown your ladyship that regardless of whether your ladyship decides the case via PAJA, it's still a rationality problem, or whether your ladyship decides the case via legality, it's still a rationality problem. On the rationality, on the facts, the case is simply not borne out at all. Then, my lady, the fourth topic is the question of a declaration or the relief that is sought. My learned friend has now abandoned the remittal, and what he's asking for is a declaration. Now, I've addressed your ladyship in relation to why it is inappropriate to enter the case at all, and it should simply be dismissed on mootness, which is the cleanest approach and the most compelling approach to this. The problem, of course, is that this relief amounts to legal advice. And the courts have said over and over and over that the powers under the Constitution are not powers to grant legal advice. There must still be a tangible dispute that remains for resolution. There must still be a lease between the parties, something tangible that constitutes a disagreement that should lead to a declaration to be granted. In a case such as this, where the events have moved on, and that any order that is granted will just be a totally pointless, a waste of time, really, that relief should simply not be granted. If I can then deal with the question of jurisdiction, to show why my learned friend is wrong on the issue that he raises on jurisdiction. Now, in section 59, which is, I've shown your ladyship that they rely on section 59, obligations are imposed on the National Assembly. In section 72, and I've quoted the section, Your Lordship, I won't repeat it, obligations are imposed on the National Council of Provinces. Two types of obligations are imposed. The one is the obligation to facilitate public involvement, and then the other is the obligation to conduct one's business in an open manner. The obligation that is invoked here is public involvement, but it is the obligation in relation to legislative and other processes of the Assembly. If my learned friend is right, this is not a legislative, but it is an other process. But the source of that obligation is still section 59. The Constitution explicitly states that if you are dealing with a failure to fulfill an obligation imposed on Parliament, that can only be resolved by the Constitutional Court, not anybody else. Now, it does not help my learned friend to say, well, I'm interested in the Bill of Rights, because my learned friend is expressly relying on section 67 and expressly relying on section 72. Those sections are about obligations imposed on the NCOP and on the National Assembly. And the Constitution talks of Parliament. Parliament, of course, means sometimes the National Assembly, sometimes both the National Assembly and the NCOP. Either way, what you have before your ladyship is that this is a matter that should be resolved exclusively by the Constitutional Court by virtue of the provisions of section 167 3E, where it says the Constitutional Court may decide that Parliament or the President has failed to fulfill a constitutional obligation. This was the finding in Doctors for Life, that if you are failing to facilitate a public engagement, only the Constitutional Court can decide the matter. This was also the finding in Lamusa. I must actually find the Lamusa judgment, that where there is a complaint about the failure to fulfill, it is actually not 2017, 2016, it's Land Access Movement of South Africa and others versus Chairperson of the National Council of Provinces. It's reported in 2016, volume 5, SA 635. And this judgment makes it clear under paragraph 6 on jurisdiction. It says section 167 4E, that's the section I just read, of the Constitution grants this court exclusive jurisdiction in respect of matters where it is alleged that the President or Parliament has failed to fulfill a constitutional obligation. The approach to this court on the primary challenge is based on this section. This court has dealt with at length with circumstances where it must exercise exclusive jurisdiction. It has held that it needs to be careful not to denude the High Court and the Supreme Court of Appeal of their power to make declarations of constitutional invalidity in terms of section 172 2A. More specifically to the issues at hand, Doctors for Life has held that the challenge there has been a failure to fulfill the obligation contained in section 72 1A, falls under this court's exclusive jurisdiction. Thus, I need not belabor the issue. Suffice to say, section 72 1A imposes the obligation only on the NCOP and not Parliament as a whole. In Doctors for Life, this court pointed out that section 42(1) of the Constitution defines Parliament as being the National Assembly and the NCOP. Where either house fails to satisfy its own obligation to facilitate public involvement in the process of making law, Parliament as a whole has failed in its constitutional obligation. I am led to the holding that this court has exclusive jurisdiction to entertain the primary challenge. So, my lady, it couldn't get worse for AFRIFORUM. We've got a case, that's two cases of the Constitutional Court. If you are complaining about section 72 1A, which is just the NCOP, if you are complaining about section 59 1, which is the National Assembly, or if you are complaining about either of them or both of them, only the Constitutional Court can deal with the matter. It's in paragraph 6 of Lamusa made explicitly. This is why my learned friend shifts from his heads of argument and tries to invoke Section 33 of the Constitution, the Just Administrative Act section. But of course, there he has to show that what he is complaining about is an administrative act. And he cannot show that this section 72(1)(a) is infringed. Now, here in his heads of argument, he explicitly says Section 5091 and 72(1) have been infringed by the conduct of Parliament. Where should he go for that? He should go to the Constitutional Court, which he hasn't done. So, on those 4 reasons, my lady, you should dismiss the application. But it seems to us preferable to dismiss the matter on the basis that it's moot, and that the argument that they've tried to mount on mootness, which relies on Buffalo City and on Gijima, is an argument that is simply utterly untenable, because it conflates 2 separate legal principles: the principle about delay and the principle about mootness. On the facts, this case is moot. If your ladyship decides the case is not moot, your ladyship nevertheless will dismiss the case because of rationality, because of the impracticability of the relief, and because of want of jurisdiction. Your ladyship, if you dismiss the application, you should really grant us our costs, because we went to the first matter in December 2018. All of the flaws in AFRIFORUM's case were explored fully in that case. Nothing has changed. And the High Court was careful not to mulct AFRIFORUM with an order, of course, because at that point, the situation was emotionally charged. But we are now 2 years after the event. We are in a scenario where the matter has progressed so much so that a bill has been produced. AFRIFORUM is trying to take us 2 years ago, and it claims that it's not playing a political game. But if one actually reads through, it's clear that AFRIFORUM is playing a political game. It's clear that AFRIFORUM is abusing the process of the court. It's clear that AFRIFORUM is trying to derail the process of Parliament. Because what on earth is it going to do with this declaration? It's going to tell a few people that, look, your submissions were excluded in a non-binding process. AFRIFORUM was told this is a non-binding process. So in the current circumstances, there is an overwhelming justification to impose a cost order on AFRIFORUM in order to stop the vexatious litigation that they have embarked upon. And so this is not a case of departing. They already didn't get a cost order against them. There is no reason why they have pursued this case up until this far, particularly despite the fact that they knew that the case is moot. They knew that they couldn't rely on Buffalo City. They knew that there was an explanation given which was adopted by the High Court. And they knew that they're relying on exclusive jurisdiction provisions of the Constitution. And yet here we are. What are we pursuing? On the probabilities, we are pursuing no more than a political case. And so one should not allow a political case to be driven to this point without consequences to AFRIFORUM. So we would urge your ladyship, when you dismiss the case, to order that AFRIFORUM is not entitled to the biowash protections. It should pay the costs of this application. This was a totally unnecessary application. It's been a waste of time. Thank you, my lady.
Advocate Nakatobi, before I allow Advocate Labuskaghni to reply, there's been the issue of condemnation for the late supplementary founding affidavit.
No, my lady, we take no issue. It was pleaded, but in reality, we take no issue. We cannot show any prejudice.
Thank you.
Thank you, my lady.
Advocate Labuskaghni.
As the court pleases. My lady, in summarizing my learned friend's argument, it seems that the following markers flow from his argument. Firstly, he says that the court au quo made findings that are binding on you. But at the same time, he says the issues that are before you are the same issues that were before the court au quo, and those issues fall within the exclusive jurisdiction of the Constitutional Court. Now, what does that make of the findings of and the judgment of the court au quo? If they weren't, if they, so we
Sorry,
don't
just on that, sorry to interrupt you, Advocate Labuskaghni, but just, I didn't understand his argument to say that the judgment of the full court is binding on me. I understood his argument to say that I'm going to need strong reasons to, or strong justification to depart therefrom, given the reasoning. Not that it was binding on the process of this court is bound by that decision, but given the nature and content of the decision, that strong reasons would have to be provided for this court to come to a different decision.
Well, milady, if that is if the position then is that it is not binding on you, then I misunderstood the debate that we had earlier on whether you are free to make your own findings and whether the fact that there were two judges who made findings of fact on papers before you, whether that did not fetter your discretion to deviate.
No, my engagement with you is different to what Advocate Nakutobi argued in that respect. He did not argue that it was binding on me. He argued that the decision of the full court was a strongly motivated, factually bound decision. And if I were to depart from it, I would need strong justification. Okay. If it was binding on me, I wouldn't be able to depart from it whether I agreed with it or not. That is how I understood that argument.
Okay, my lady, I think if that is the vantage point from which we look at the judgment of the court au quo, then I would reply that there are two things that the court needs to take into account. And that is firstly, that as a court, your ladyship has an unfettered discretion to determine the matter on the material before you. Although in forming your view, you may take note of what the court au quo had said, it would be a misdirection for this court to suggest that somehow you have to find reasons to differ. What we submit is that this court has a free discretion, unfettered by the judgment of the court au quo. That is for a number of reasons, my lady. My learned, my client, in approaching the court under Part B, is asserting in itself a constitutional right to be heard under Part B. And if the hearing under Part B is somehow in effect predetermined or influenced by findings under Part A, that affects the fairness of the process under Part B. Now, the only way to avoid that unfairness is to impose upon this court an unfettered discretion. That would be the way in which the constitutional imperative of a fair hearing would be given effect to. And for that reason, our submission is that your ladyship is free to make findings of fact on all the material before you, even if it's served before the court au quo. To deviate from that on the basis that somehow the findings are either binding on you or that you have to in yourself find reasons not to agree, that in itself demonstrates a degree of fetteredness which we say should not be present in your mind. That deals with what I've just roughly called the effect of the judgment on the court au quo is concerned. My lady, my learned friend's argument on mootness has this novel component that he makes the submission that despite constitutional court authority, that Gijima and Asla and Buffalo City impose the obligation on a court to set aside conduct which is unconstitutional. On a learned friend's submission, you have the discretion not to do so if you find it to be moot. Now, that we say is a novel consideration. We might refer your ladyship in this regard. Let me refer you to a judgment of the Constitutional Court. And that's what it says here. It is the president of the RSA versus the DA. It's the DA matter my learned friend referred to, but the Constitutional Court judgment. It's reported at 2021 SA 428 CC. In that particular instance, there had been a withdrawal of proceedings, main proceedings before a previous judge, but the president wanted to get rulings on certain issues affecting the exercise of his powers to appoint ministers. In paragraph 16 at page 434, having gone through various provisions, the Constitutional Court by means of the Chief Justice says the following. These positions not only accord with the mootness provisions of the Superior Courts Act, but are also informed by our jurisprudence. For even this court has previously said that where issues are of such a nature that the decisions sought will have no practical effect or result, the appeal may be dismissed on this ground alone. This would ordinarily put an end to the application, but this court has the discretionary power to entertain even admittedly moot issues. In Langeberg, we've said a discretion to decide issues on appeal, even if they no longer present existing or live controversies. That discretion must be exercised according to what the interests of justice require. Now, my lady, this would be in an instance where section 1721A was not the primary objective of the proceedings. In that matter, even though it were moot, the Constitutional Court embarked upon considering whether the interests of justice do not in any event dictate that a decision should follow. Now, in this particular instance, we have in the papers indicated that the declarator that we seek is consistent with the obligation imposed upon the court in terms of section 1721A. It is enforced by Gijima. It is enforced by Buffalo City. And our learned friends, with respect, cannot run away from Gijima. Excuse the pun. As far as the interests of justice in granting the order is concerned, the fact that it will guide Parliament's committees is not a speculative or advisory issue. It will direct their conduct. And that is a direction on a constitutional issue arising from the public participation provision proceedings that we've referred to. Now, lady, that is a significant relief. And for that reason, our submission is that you're not being asked to give an opinion on something that is moot. You're requested to direct something that is unconstitutional to be unconstitutional, knowing that it will guide the conduct of parliamentary committees in future. Arising from a learned friend's further interactions with your ladyship, a further considerations relevant to the interests of justice has been identified. And that is, my lady, that if committees of Parliament need to know according to what standard their decisions will be judged, that in itself gives direction to parliamentary committee proceedings. If they need to know whether they are subject to pacha or whether they are subject to the legality provisions and need to meet the rationality and legality arguments, those are all matters which are of some import in giving direction to the proceedings before the parliamentary committees. And for that reason, our submission is that the relief that we seek is not only enjoined by section 172, but will guide the conduct of Parliament in a real and material matter on aspects on which the jurisprudence has not yet pronounced. And that is the pre-legislative processes. Doctors for Life dealt with public participation during the legislative processes. And our submission is therefore that it is a case properly made out for the relief under Part A, and that for that reason, the application should be granted. My lady, we seem to have lost you for a moment. I can't hear what you are saying, my lady. You might be muted.
I said I was just opening a bottle of water, so that's why I put the video off. So I was just getting some water.
Did right. We lost you for a moment on this side, and we were just concerned for your well-being.
Thank you. I'm following what you say.
My lady, I think to wrap it up then, our submission is that mootness in itself is not a consideration for relief under Section 1712A. If it were, your ladyship has a discretion nevertheless to be exercised judicially to grant the declarator, but you would with respect be entering into novel territory if you accepted our learned friend's submission that if a matter is moot, you need not grant a declaratory order without considering the interests of justice. Those interests we have already submitted point in two directions, and that is that the order would give effect to the proceedings of Parliament, and further that the standard of conduct against which their decisions, the standard against which their decisions would be met would flow from the ruling that you make in this regard. And we therefore move, my lady, for the relief as sought in Part 1, Prayer 1, Part B, and we move so with costs, including the costs of the previous proceedings, as the court pleases.
Thank you. I'm not going to give judgment immediately. I think the parties anticipate that I'm going to reserve judgment. The judgment will, however, be delivered electronically as well. So the parties will be notified and the judgment will be emailed to the parties, but judgment is reserved at this stage. Thank you very much to the parties for arranging the meeting and for being patient when we experience technical difficulties. Once again, the court is indebted to both parties for the comprehensive and very helpful heads of argument and the authorities referred thereto. Thank you. Then this matter will adjourn and judgment will be reserved. Thank you.